Just when you thought the Joe Biden Department of Justice could not stoop even lower when it comes to our right to keep and bear arms, wait till you see what they're trying to do to the lawyers and to the gun owners of America in a fight about attorney's fees involving our, meaning the Second Amendment community's, big win before the United States Supreme Court in the bump stock fight. You're not going to believe what DOJ is doing now. Terrible, pathetic, awful. Let's explain why when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the Georgetown Journal of Law and Public Policy article, Dangerous but Not Unusual, Mistakes Commonly Made by Courts in Post-Bruin Litigation. Check out a free copy from the Georgetown School of Law in the link to this video. A lot of detailed scholarship, history, 65 some odd pages. Check it out if you don't already have a copy. Just download the link and send it to your friends or read it yourself. Okay, folks. So we're going to get a little geeky on attorney's fees, and this is really going to teach us all in the Second Amendment community the importance of private donations, donating to Second Amendment groups that fight every day in courts for our right to keep and bear arms. The Gun Owners of America, the Firearms Policy Coalition, the Second Amendment Foundation, the NRA, the California Rifle and Pistol Association, and on and on and on. I can keep on going. You know the groups. They're all in your communities. And we've talked a lot about them on these channels. But this video is really going to show you why the comment by Benjamin Franklin after the signing of the Declaration of Independence that says we in the Second Amendment community, that's not exactly what Ben Franklin said, but what Franklin said was we must hang together or we most assuredly will hang separately. That metaphor, that statement from Franklin at the time of the signing of the Declaration of Independence holds true to the Second Amendment community today, in my opinion, which is it just is what I'm about to tell you really shows that we in this community must hang together and fight together for our right to keep and bear arms in whatever way we can. Not everyone can have a YouTube channel. Not everyone can be good at shooting guns. Not everyone can be in a position to donate financially, but we all have to work together. And this video showing what the Biden Department of Justice is doing to the gun owners of America and to the other plaintiffs that successfully challenged the bump stock case in the U.S. Supreme Court, along with, for example, Michael Cargill and others, really speaks to the way the government views us. Okay, so with that backdrop, here's what's going on. As you recall, the United States Supreme Court in the Cargill case against Merrick Garland and the Biden Department of Justice found that the ATF's attempt to include bump stocks in the definition of machine guns under the National Firearm Act failed. The Supreme Court said no can do. Can't do it. A bump stock is not a machine gun under the definition of machine gun in federal gun control law, specifically the National Firearms Act. This law, this interpretation by ATF was challenged all the way up to the Supreme Court by many organizations, ultimately won by Michael Cargill and others. Now, in light of that victory, the lawyers and the parties are what are known as prevailing parties, meaning they won the case. So the Gun Owners of America, having won one of the cases arising out of Michigan in the U.S. Court of Appeals for the Sixth Circuit, right, and supporting the case of Cargill in the U.S. Supreme Court, they have filed a motion to be paid their attorney's fees. The cost that they had to pay to their attorneys to seek the relief and to get the relief and to ultimately win, of course, in the U.S. Supreme Court. Okay? Makes sense. You won the case. You should get your attorney's fees against the government. Well, as it turns out, Joe Biden Department of Justice is fighting this tooth and nail. They don't want to give the Gun Owners of America a dime, any money. And if they are going to give them money, they want to pay the lawyers a very small fee, which we will get to in just a couple minutes. But to begin with, here is what the federal government, now mind you, when I'm going to read this, I just want to remind you one thing. As of this moment, we have given to the Ukraine as a country somewhere on the order of magnitude of $64 billion. Now, you can support the Ukraine, you can hate the Russians, I get it, that's fine. I'm not disagreeing with that. as a matter of policy. But just to put this into context, $64 billion has been paid for by American taxpayers to Ukrainians to fight against the Russians. Our national debt is $36 trillion with a T. $36 trillion with a T. So with that said, let's see how our federal government, our Biden Department of Justice, is trying to save money, big money supposedly, given these numbers, by preventing Second Amendment prevailing parties that have defeated the ATF from getting paid a dime of the attorney's fees they had to incur to vindicate our rights against the federal government. Here's what DOJ had to say in their brief opposing this attorney fee petition by the gun owners of America. They write, "The court should deny plaintiffs' motion for attorney's fees under the Equal Access to Justice Act. Fees are not payable under the EAJA when the government's litigation position was substantially justified, meaning that the government's position had a reasonable basis in law and fact, even if the government did not ultimately prevail in the action. Here, the government's position was substantially justified because the Bureau of Alcohol, Tobacco, Firearms, and Explosives relied on reasonable interpretations of the statutory phrases automatically and single function of the trigger when promulgating the final rule at issue in this case. Likewise, the federal government adopted reasonable positions while defending this case. Indeed, the reasonableness of the government's interpretation and positions are evident from the thoughtful decisions of numerous district and circuit courts who agreed with the government, including this court, as well as the dissent of 3 Supreme Court justices in Garland versus Cargill." And again, this is the government's position to say that under the relevant law, they don't have to pay the prevailing attorneys, the prevailing parties, a dime in attorney's fees. Now, I want to draw a key distinction here. You may be familiar with the Civil Rights Acts. You may be familiar with 42 U.S.C. 1988. That is a civil rights act, a civil rights statute that can be used to get attorney's fees when a plaintiff wins in a civil rights case against a state or local government agency. Okay? 42 U.S.C. 1988, which gives you attorney's fees if you're the prevailing party in like a Second Amendment case or a First Amendment case, does not apply, listen carefully, does not apply to cases brought against the federal government. The federal government, which means if you sue the federal government involving like ATF interpretations, you don't get your attorney's fees unless the government basically overreaches. If there's a substantial argument in favor of the government, you don't even get your attorney's fees, even if you win at the Supreme Court. And 42 U.S.C. 1988, which you get your attorney's fees in lower courts against state and local governments, that doesn't apply. It doesn't give you the benefit against the federal government. So you have to turn to the EAJA, the Equal Access to Justice Act. And that, again, specifically says you don't get your attorney's fees as a general matter. Here's what it says according to the Department of Justice in this brief against the gun owners of America. The statute reads, "A court shall award to a prevailing party other than the United States fees and other expenses incurred by that party in any civil action, including proceedings for judicial review of agency action brought by or against the United States in any court having jurisdiction of that action, unless, listen carefully, unless the court finds that the position of the United States was substantially justified or that special circumstances make the award unjust." Now again, the government's argument is our position was substantially justified. We had a reasonable basis for arguing that bump stocks were machine guns. As proof of that, even in the Supreme Court, the Second Amendment ruled only won 6-3. And a lot of lower courts agreed with our, meaning the ATF's position. So that's really their argument. Now, I also want to remind you one other thing that's key about this. And this is why I think these private donations to these nonprofits or these groups that support the Second Amendment are so important. Because in addition to the fact that the federal government, brings these kinds of arguments to say we're not paying you a dime, despite the fact we're willing to give the Ukraine $64 billion. If you vindicate our Second Amendment rights, if you shut down government overreach, you're not going to pay you a dime. That's our position. Because you're not Ukrainians, right? You are peasants. You're peons. You don't count. That seems to be the legal position of the Department of Justice under Joe Biden here. And to make matters worse, keep this in mind. Remember how I've always taught you that the bad gun control laws arise in jurisdictions that have bad anti-gun politicians and often have bad anti-gun judges, because those are the people that are selected for those judgeships by whom? They're selected for those judgeships by the anti-gun politicians that help pick and select judges. So in New York, for example, you get a lot of bad anti-gun judges because they had to be blessed by Senator Chuck Schumer and Senator, Kristen Gillibrand, right? It's just kind of how a lot of the stuff works. Judgeships are often politically oriented. You got to be known to the politicians to get the nominations and get confirmed and so on. So I bring this up because in addition to the fact that our Department of Justice, with their $1 billion+ budget, multi-billions of dollars, are deployed against the gun owners of America and people to try to deny them from getting their pay for the work they did on defeating that absurd bump stock rule. You also have to recognize that these arguments are being heard by whom? They're being heard by judges in these jurisdictions in many instances that have bad judges. Bad in the sense that they're anti-Second Amendment. They don't like the Second Amendment. They don't like guns. They don't like gun owners. So do you think they're going to bend over backwards to find a way to get the attorneys for these Second Amendment groups to be paid? Guess what? They're not. They're simply not. In my opinion, and my experience is that's consistent. They just don't want to pay people to fight for the Second Amendment because they don't like the Second Amendment, they don't like guns, and they don't like gun owners. It's just, that's how it works. Now, to add insult to injury, now this is going to get a little, attorney fee geeky here. Beyond the fact that the Department of Justice doesn't want the gun owners of America to get any attorney's fees, they then argue that if they are entitled to attorney's fees, their attorney should only get the statutory rate under the EAJA of $125 an hour. Now, $125 an hour may sound like a lot of money to some, and it is a lot of money to some people. But you got to put this into the context of top lawyers and lawyers in the United States. You can argue this is good or bad. This is what the market dictates. It's the way it is. Top lawyers in the United States at the elite levels are over $2,000 an hour easily. At the elite levels, okay? A Supreme Court law clerk that leaves the clerkship of the Supreme Court to go to a private firm is likely going to get a bonus, a signing bonus, separate from salary, separate from Christmas bonuses and the like, a signing bonus of probably in the neighborhood of $400,000. A first-year associate at my own law firm that I started at when I was a young lawyer, first-year associate right out of law school, wet behind the ears, is going to get somewhere around $230,000 a year. Okay? Now, I'm only giving you these numbers to give you a sense of what the Department of Justice is saying that the gun owners of America's lawyers should get, if anything, right? They argue you should get zero, but they're saying that at most these lawyers for the gun owners of America should only get $125 an hour, and that's it. And when you compare that number against the opportunity costs that lawyers can get paid doing other kind of work outside of the Second Amendment, meaning outside of the context of getting paid from the government for prevailing in a case in the U.S. Supreme Court, you can see the potential problem here, which again is why this Joe Biden Department of Justice is trying to discourage people from bringing cases against the ATF and in support of the Second Amendment by stopping them from getting their attorney's fees. And if they do get attorney's fees, they're going to get paid that ridiculously low. And that's the reality of for lawyers in America today. If you're good, if you're a top lawyer, $125 an hour, which is, of course, not a big number, even though that's a statutory rate. And the Department of Justice here is literally saying that the gun owners of America attorneys are not entitled to any kind of special enhancement or any special privileges or anything above that 125 number because they don't have special training, and they have all sorts of other arguments in this brief, which I'll put a link to the brief down below, and you tell me what you think. But the bottom line is, I think the lesson here is we must realize that even if you win at the Supreme Court, our federal government is going to fight tooth and nail to deny our Second Amendment Amendment community the resources we need to prevail in these cases. And if we prevail in these cases, they're going to deny us the resources we need to pay our lawyers, which really speaks, in my opinion, to the importance of donations and supporting financially and otherwise our Second Amendment related organizations such as the Gun Owners of America, because again, they're not going to be able to recover their attorney's fees as a general matter, given the sort of nonsense we're seeing here from this Department of Justice. Now, I'm hopeful that when Donald Trump gets in there, maybe the Department of Justice under Donald Trump will be better on these kinds of issues. But again, that's going to take a while before we see that. And of course, this all assumes you win the case, because of course, if the Gun Owners of America and others had lost the case before the Supreme Court, then we wouldn't even be having this conversation, because all that money would be out the window and be 0% chance of getting paid anything, even the $125 an hour. And again, DOJ right now doesn't want the Gun Owners of America to get paid a dime. Terrible, terrible, terrible. But that's the world we live in, and that's the world we must fight through, and that's the one we are fighting in right now. All right, folks, hope you learned something here today. Make sure you follow me on X at 4boxesdarn. Don't forget to like this video and subscribe. We're trying to get to 200,000 subscribers on this channel. Remember, I'm now posting this on Rumble for people that like to use Rumble, so I'm doing that as a courtesy to our fans over there, and I look forward to talking to you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.